Hello friends, welcome to Ignite IAS. This is Prithvi. Today we are going to discuss the polity questions from yesterday's preliminary examination of UPSC. Right. So, if you try to look at the polity paper, most often we are able to come across subjective questions, more of interpretive in nature. So, which is very difficult to answer if you don't have the in-depth knowledge in the polity. Okay, so let us get into our discussion. First question: by which of the following acts Governor General of Bengal designated as Governor General of India? Okay, so it is a direct question and very easy question. So Regulating Act, Pitt's India Act, Charter Act of 1793 and Charter Act of 1833. Actually, the Governor General of Bengal, the Governor of Bengal has been designated as Governor General of Bengal by the Regulating Act. Only later, by the Charter Act of 1833, the Governor General of Bengal has been designated as Governor General of India. So hence the answer is D is the right answer. Coming to the 11th question, in an essence, what does the due process of law mean? So this is very important question. With this question, we can easily identify UPSC does not ask the questions only from the bare constitution. Rather, it also asks the questions from the judicial interpretations also. This is a live example. In this particular question, actually if you try to look at Article 21 of the Constitution, nowhere the term due process of law has been mentioned. It has been interpreted, Article 21 has been interpreted to include due process of law by the Maneka Gandhi versus Union of India case of 1978. So in this case, the judiciary for the first time raised the bar of judicial interventions into the legislative and executive activities. In fact, Article 13 warrants the judicial interventions only when something goes against the constitution. But by means of this particular case, judiciary assumed the position of the super legislature, where it keep on asking the legislature and executive the questions regarding the reasonableness, fairness, and justiciable. So these questions will be raised by the judiciary. Especially in the Maneka Gandhi case, judiciary had raised the questions of principles of natural justice. Okay, because the arbitrary executive action, if it is taking the source of power from the arbitrary legislation, the judiciary will be questioning the very legislation which is authorizing the executive to do certain arbitrary things. In this essence, the judiciary assumed the position of the super legislature by seeking the answers from the legislature whether it has followed the principles of the natural justice or not, and similarly asking the questions to executive whether it has followed the principles of the natural justice or not. So here the right and apt answer would be A is the right answer. Few of the aspirants may prefer to choose option C as the right answer, but it is limiting the judicial intervention only to the executive, which is not allowing the judicial oversight over the legislature. So hence the option A is the right answer as far as the 11th question is concerned. Okay, right. What are the three principles of the natural justice? No man is the judge of his own case, and no man shall be condemned unheard, and absence of the bias. These three principles are called principles of the natural justice. Okay, and the very context of principles of the natural justice has been raised in the case of Indian Passports Act, where Maneka Gandhi's passport was arbitrarily taken by the state. So such question was asked by the judiciary, stating that it will not only be prohibiting arbitrary executive action, but it would also prohibit arbitrary legislative action as well. So hence the right option would be A is the right answer. Because Maneka Gandhi's passport was impounded by not following the principles of the natural justice. She was not given adequate opportunity to explain her side. Okay. Coming to the 12th question, consider the following statements. So coming to the statement number 1, in India, prisons are managed by the state governments with their own rules and regulations for the day-to-day administration of the prisons. Actually, prisons fall under the state list. And in India, persons governed by the Prisons Act 1894 were expressly kept the subject of prisons in the control of the provincial governments. So here both statements are correct. In fact, it is a direct question. So answer is A. A is the right answer. Where statement number 1 is correct and statement number 2 is the right explanation of the statement number 1. Next, coming to the 13th question, which one of the following statements best reflects the chief purpose of the constitution of a country? Right? It appears that it is so easy question, but sometimes aspirants may commit the mistakes while attempting the easy questions. Okay, right? Look at the statements. It determines the objective for the making of the necessary laws. It enables the creation of political offices and a government. It defines the limits and the powers of the government. It secures social justice, social equality and social security. So it appears every option is correct. But what we have to understand, we have to give the relative preference to one of the given options here. So hence the right option would be, it defines the limits over the powers of the government. Okay, because in fact the Constitution of India grants the constitutional government. What is the meaning of constitutional government? It is the government which is operated under certain checks and balances, under certain limits. Okay, no absolute authority has been given to the government. So hence the right answer would be C is the right option. Okay, right. Coming to the next question, 14th question. In India, which one of the following constitutional amendments was widely believed to be enacted to overcome the judicial interpretation of the fundamental rights? So the moment this particular question flashes in our mind, we must remember, we must recall Chempakam Durai Rajan versus State of Madras, which is a landmark verdict, okay, which has said that under Article 15 of the Constitution, no reservations can be provided. But subsequently what happened, in order to overcome this particular judgment, the first Constitutional Amendment Act was enacted. Okay, the first Constitutional Amendment Act has inserted new classes to the Article 15, that is Article 15 Class 4 has been added. Similarly, Article 31A has been added, Article 31B has been added, even 9th schedule was also added to the Constitution by the very same amendment. So hence, what is the right answer? First option is the right answer. Few of the aspirants may also identify 42nd amendment also as an answer. But in fact, if you try to look at the nature of 42nd Constitutional Amendment Act, even before that, 24th and 25th Constitutional Amendment Acts were also enacted. So it means there will be multiple answers for the same question. So that's why the relative and right answer would be the first amendment, because for the first time, the judicial interpretations were to be overcome by the Parliament by means of the first Constitutional Amendment Act. It is a beginning phase for the constitutional amendments to take place in the country. Okay, so hence first option is correct, that is A is the right answer. Next, coming to the 15th question, consider the following organizations or bodies in India. See, it is very simple question, very easy question. Okay, there are 4 options have been given. One is National Commission for Backward Classes, National Human Rights Commission, National Law Commission, National Consumer Disputes Redressal Commission. Out of which National Commission for Backward Classes is the only constitutional body which has been granted under Article 338B of the Constitution. Okay, so hence all the other 3 options are incorrect, because National Human Rights Commission has been provided under Protection of Human Rights Act. So of 1993, it is a statutory body. Similarly, National Law Commission is an executive body. Similarly, National Consumer Dispute Redressal Commission, which has been created under the Consumers Protection Act. So hence, this is also a statutory body. So the constitutional body would be only one. Okay, that is National Commission for Backward Classes. Next, coming to the 16th question, this is a relatively easy question. In fact, if you understand the right process of the presidential election and presidential powers. Okay, right. First one, if the election of the President of India is declared void by the Supreme Court of India, all acts done by him in the performance of his duties of his or her office of President before the date of decision become invalid. This is in fact, it is incorrect statement, because Article 361 actually provides the special privileges to the President of India. Not only that, Article 74 as well as Article 53, which makes the President of India as a nominal authority, because every decision has to be done according to the advice of the Prime Minister and Council of Ministers. So it means the President of India will not be possessing any personal liability for the decisions he has taken during the time of his office. So hence first statement is incorrect. And coming to the second statement, election for the post of president can be postponed on the ground that some legislative assemblies have been dissolved and elections are yet to take place. This is also incorrect statement, because even though certain legislative assemblies are not in the operation, or elections are in due, or even certain seats are vacant, this cannot be the reason for the postponement of the presidential election. And coming to the statement number 3, when a bill is presented to the president, the constitution prescribes time limits. In fact, the very problematic provision with respect to the bills is the time limit has not been specified. That is the reason why Jail Singh has exercised the pocket veto. Actually, pocket veto has not been mentioned, the term has not been mentioned in the constitution, but because the time has not been mentioned in the constitution, they can take the decisions in the longer time also. Right, but this particular time limit has been specified in the case of American president, but not in the case of the Indian president. Okay, so what is the right answer? D is the right answer, because none of the above statements are correct. Coming to the 17th question, with reference to finance bill and money bill in the parliament, consider the following statements. Okay, do you know what is finance bill, what is money bill? Even finance bill and money bill, both are money bills only. Okay, because if you try to look at the phases of enactment of the budget, we will come across 3 important phases. One is voting on demand for grants, second one is appropriation bill, and third one is the finance bill. Finance bill is something which authorizes the income side of the government. So the taxation proposals are usually mentioned in the finance bill. So it means it is attracting which article of the constitution? Article 110 of the constitution. Similarly, the money bill is explicitly defined under Article 110. So which talks about the transactions of the Consolidated Fund of India alone. Okay, the transactions of the Consolidated Fund of India, that is mentioned under Article 110 of the Constitution. So hence in this light, let us understand the various dimensions of this particular question. First one, when the Lok Sabha transmits the finance bill to the Rajya Sabha, it can amend or reject the bill. In fact, finance bill cannot be amended, cannot be rejected. Financial bill is different, finance bill is different. Okay, right. And when the Lok Sabha transmits the money bill to the Rajya Sabha, it cannot amend or reject the bill, it can only make the recommendations. This is also a right statement. Okay, this is the right statement. And third one, in case of disagreement between Lok Sabha and Rajya Sabha, there is no joint sitting becomes necessary for the finance bill. So again, joint sitting is not available with respect to the finance bill. So the answer would be, okay, what is the right answer? Only one is correct, one only. But in some situations, people may also take the second one also as the right answer, because sometimes they may interpret finance bill as a financial bill, but financial bill is different and finance bill is different. Okay, financial bill is defined under Article 117 of the Constitution. So financial bill has 2 types, financial bill 1 and financial bill 2. Okay, right. So you must take this particular question into the consideration. Next question is 19th question. With reference to schedule areas in India, consider the following statements. First one, within a state, notification of an area as schedule area takes place through the presidential order. Yes, it is true, because the President of India will be exercising the powers over the schedule areas. Okay, right. Second one, the largest administrative unit forming the schedule area is the district and lowest is the cluster of the villages in the block. It could be block or taluka also, anything could be the right answer. Okay, both these 2 statements are correct. Coming to the third one, the chief ministers are required to submit the annual reports to the Home Ministry on the administration of the schedule areas and schedule areas in the states. But in fact, this particular third statement is incorrect. So it will become correct only if the chief ministers are to be replaced by the governors. So in the place of chief ministers, what must be there? Governor must be there. So what is the right answer? Only 2 statements are correct. Hence B is the right answer. Write down question number 20. Statement number 1, the Supreme Court of India has held in some judgments that reservation policies made under Article 16 Clause 4 of the Constitution of India would be limited under Article 335 for the maintenance of the efficiency of administration. Actually, this is the right statement. Why? Because in the Nagaraj versus Union of India case, Supreme Court has given certain safeguards against the misuse of reservations, stating that in case if anybody wants to claim the reservations in the promotions, especially, there are certain things must be demonstrated by the state. What are those? Suppose it has to demonstrate the backwardness of such communities, inadequacy of representation of such communities, and third one is there is no more problem to the efficiency of the administration. These are the three things have been given by the Supreme Court in that particular judgment. So hence statement number 1 is correct. Statement number 2, under Article 335 of the Constitution, it is defined, the efficiency of administration has been defined. Okay, the efficiency of the administration has been defined. But is it true? It is false. Actually, Constitution is silent with respect to interpretation of the many terms in the Constitution. Not only this efficiency, but also secularism, sovereignty, socialism. There are various terms which are not defined by the Constitution. So this also falls in the same line. Okay, so hence statement number 2 is incorrect. So then what is the right answer? Statement number 1 is correct, but statement number 2 is not correct. So C is the answer. Okay, right. Next, coming to the 51st question, with reference to home guards, consider the following statements. Okay, three statements have been given. Home guards are raised under the Home Guards Act and rules of central government. In fact, the home guards have been raised as a voluntary force. There is no specific statute which would govern the home guards. So hence statement number 1 is outrightly ruled out. Next one, second one is the role of home guards is to serve the auxiliary force to the police in the maintenance of the internal security. Yes, this is true. Okay, because wherever the internal security is threatened because of the communal clashes or various other reasons, the home guards assistance can be taken. Number 3, to prevent the infiltration on international borders or coastal areas, the border wing home guards battalions have been raised in some states. For example, in the state of Rajasthan and other border states, these home guards have been raised. So hence, what are the right options? 2 and 3 statements are correct. Hence, the right answer is only 2. So coming to the 52nd question, with reference to India, consider the following pairs. Unauthorized wearing of police military uniforms and knowingly misleading or otherwise interfering with the police officer or military officer when engaged in their duties. Celebratory gunfire which can endanger the personal safety of others. How many of the above pairs are correctly matched? Okay, so actually all the 3 statements are correctly matched. Okay, C is the answer. 64th question. Consider the following statements in respect of national flag of India according to the Flag Code of India of 2002. 2 statements have been given. First one of the standard sizes of the national flag of India is 600 mm into 400 mm. Actually, this dimension is wrong according to the list of dimensions that have been provided in the code. 9 dimensions have been provided where this particular statement does not fit into such dimensions. So hence, statement number 1 is incorrect. Coming to the second one, the ratio of length to height of the flag shall be 3:2. This is correct according to the Flag Code of India. Hence, what is the right answer? Statement number 1 is incorrect, whereas statement number 2 is correct. Right, D is the answer. Coming to the 65th question, consider the following statements in respect of Constitution Day. The Constitution Day is celebrated on 26th November every year to promote constitutional values among the citizens. Yes, because it is the date of adoption of the Constitution. Okay, because it has been clearly mentioned in the preamble. Coming to the statement number 2, 26th November 1949 is the date on which Constituent Assembly of India had set up a drafting committee under the chairmanship of the Dr. B.R. Ambedkar to prepare a draft Constitution of India. This is completely incorrect because 26 November 1949 marks the date of adoption of the Constitution. So hence, what is the right answer? First statement is correct and second statement is incorrect. So C is the answer. Coming to the 97th question, according to the Constitution of India, the central government has a duty to protect the states from the internal disturbances. Yes, it is true because under Article 355 of the Constitution. And also Article 365 also talks about the same. Coming to the second statement, Constitution of India exempts states from providing legal counsel to person being held for the preventive detention. Actually, section 22, class 3 of the Constitution provides the exemptions for the safeguards provided under article 22, class 1 and class 2. Okay, article 22, class 3 acts as exemption for article 22, class 1 and class 2. Okay, in this sense, which says that a person who is enemy alien, or if a person is arrested under the preventive detention, he will not be facilitated with the legal counsel. So that is the essence which is reflected under article 22 class 3. But multiple interpretations are possible here, because article 22 class 5 says that within the reasonable time the representation shall be made for the person who is under the preventive detention. Similarly, article 22 to class 6 also provides the exemption for article 22 class 5. So it means since article 22 class 3 appears first in the row of various clauses, hence we are choosing article 22 class 3 as the right answer. Okay, right. Next one is, according to the Prevention of Terrorism Act of 2002, confession of accused before the police officer cannot be used as an evidence. Actually, opposite is true. Usually, under article 20 of the Constitution, there is no scope for the self-incrimination. What is the meaning of self-incrimination? Nobody shall be forced or pressurized to act as a witness against himself. Okay, so hence this particular POTA Act of 2002 gives the exemptions to article 20 of the Constitution, stating that if a person is under the police custody, if he gives any confessionary statement to the police officer, that can be valid even in the court of law, because in the terrorist related offences it is very difficult to find out the culprits. So hence the confessional statements can be made as an admissible evidence in the court of law. So hence third statement is incorrect, because it says cannot be. If it is there, can be means that is the right statement, hence it is a wrong statement. Okay, right. What is the right answer? B is the right answer. Okay, only 2 is the right answer. Next, last question. Consider the following statements in respect of election to the President of India. Okay, right. This is very factual question, right? Because you understand, in the integrated course we will get ample time and we will give a detailed notes to the students, and most often that notes will be very essential and very indispensable to clear the preliminary examination. Okay, so that's why this integrated course is becoming a boon for the civil services examination and civil services preparation. Okay, and this Ignite is very much right option, because we do not complete the syllabus in a hurry-burry manner. We will detailedly deal with the any subject syllabus, not only polity. Okay, right. So here look at this particular 100th question. Consider the following statements in respect of election to the President of India. The members nominated to either house of the parliament or legislative assemblies are eligible to be included into the electoral college. Okay, actually in the electoral college, who are the members? Only elected members of the Lok Sabha, elected members of the Rajya Sabha, elected members of the state legislative assemblies. Hence, first statement is incorrect. Right, and higher the number of elective assembly seats, higher is the value of the vote of each MLA of that state. In fact, it is not true. The vote value of MLA is dependent upon a formula: total population of the state divided by total number of the elected representatives in that state. So naturally, if elected representatives are increasing, what will happen? The vote value of the MLAs will be decreasing. So there is an inverse proportionality between the vote value of the MLAs and total number of elected representatives. So hence, second statement is also incorrect. Coming to the third statement, the value of vote of MLA of Madhya Pradesh is greater than that of Kerala. In fact, Madhya Pradesh population is higher than Kerala. But what is the problem? I told you just now, when number of MLAs are increasing in the legislative assembly, what will happen? There is a chance that the vote value of the MLAs will be decreasing. So here the same thing took place. Okay, so hence the Kerala MLA population vote value is more than that of the vote value of the Madhya Pradesh MLA, despite the lesser population of the Kerala state. So hence third statement is incorrect. Coming to the fourth one, the vote value of each MLA of Puducherry is higher than that of Arunachal Pradesh, because the ratio of total population to the total number of elective Puducherry is greater compared to the Arunachal Pradesh. So this is the only right statement which is there in the 100th question. Hence the answer is A. I hope you have understood the very essence of the questions. Most of the questions are philosophical, analytical. Okay, this requires a very thorough preparation. Okay, so without which you can't attempt the questions in the examination, and you need to prepare a detailed notes, and you need to be very much analytical and philosophical. You need to understand the philosophy of the constitution also, and the very essence of the judicial pronouncements also. Okay, right. Thank you. All the best.